Raj Shah, partner at Square Feet Realty Consultants, and I also run Mumbai Realty Club. I'm going to quickly give a short presentation on Mumbai Realty Club, and then we'll hear Mr. Anil Harish on what he has to tell us about the capital value based property tax and TDS on sale. So Mumbai Realty Club is meant for realtors, and we want to help you succeed and scale up. So who are we? We are a trusted circle of realtors, and we've just started with our Bandra and Dadar chapter. So as you can see, Bandra and Andheri chapter, we've got about 33 members. Currently it's a free forum, it's an email-based group. Dadar Chembur, we've got 28 members. Again, it's currently a free group. And South Mumbai chapter, which has been in existence for about a year and a half too, we've got 75 members, and that's a paid model. The reason why it's paid is because we offer something called as property assist, and I'm going to come to property assist in a bit. So we have a lot of forums, so why is this one different? One is that it's a trusted circle of realtors. So once a new member wants to join in, the current members will vote on the application. So you're ensure of a quality circle that you're interacting with. Second, it's local. So we are zonal. So you won't have members in South Bombay posting about Vasai or New Bombay for that matter. Yes, of course, there's a little bit of overlap, fair enough, but like you're going to have people talking about Parel in South Bombay and in Dadar Chembur, but otherwise it's fairly zonal. So what do? We give realtors tools to succeed and scale up. You'll say fine, but how is the question. Okay, here's a service called Property Assist. Here's what we do. A member has sent this email. I'm giving you a snapshot of what Mr. Gaurav Kapoor, who's a member with us, starts asking, sends a query saying that I need a 3-bedroom on rent for 2.5 lakhs on email. And what we do is we match the properties. As you will see now, we'll match proposals along with broker names and numbers and send it back to you, therefore saving you valuable time. So in this example, in about 13 minutes, my guy, my property assist database manager, has replied with proposals, and in this case he's got 43 proposals. So which means you're saving a lot of time and effort. The idea is to ensure that you guys spend less time managing data and more time closing deals. We also have certain forms to ensure that your work becomes smoother and stress-free. So on my website, mumbairealtyclub.com, you can go to downloads, you can go to residential or commercial, and what you will see is there are certain forms. What do these forms do? Now these are forms in Excel sheet, but these are professional forms which gets you critical details upfront. Everything about what the property is, square feet, etc., including brokerage confirmation. The idea is that you'll stress less while you are doing your transactions and therefore close more deals. We also do personal training. We've done recently, just finished one with Shalini's office. The idea is that we try help you streamline your processes in your office and give you support on technology. So how to use certain Google Docs and all of that, just to ensure that your office functions a lot more smoother than it currently does. So to succeed and scale up, if you aren't already a chapter member, we would request that you sign up. You can go to our website and sign up. Before I introduce our guests for today, I would like to request you all to please keep your phones on silent. If in case you need to take a call, you can please go outside the hall and take that call. If you have questions for Mr. Anil Harish, please, we provided you with pads and pencils. Please write them down. At the end of the session, we're going to have a question and answer module. And at that point in time, we'll request Mr. Anil Harish to answer your queries. So it gives me great pleasure to introduce Mr. Anil Harish. Mr. Anil Harish specializes in the field of corporate law, joint ventures and collaborations, property mergers and acquisitions, demergers, LLPs, taxation, arbitration, exchange control, foreign investment, trust, wills and Indian and international taxation. There is nothing that escapes him. He is involved in other institutions in the legal field such as the Society of Indian Law Firms, of which he is the Executive Vice President. He is also a member of the Committee on Dispute Resolution of the CII, Confederation of Indian Industry. As a specialist in the field of real estate, Mr. Harish is also involved with the magazine Propertyscape as well as the Accommodation Times Institute of Real Estate Management. Mr. Harish has written articles which have been published in the Times of India, Hindustan Times and several professional journals. He is a director of several prestigious public limited companies in India. He is involved in several education and charitable trusts and is the former president of Hyderabad Sindh National Collegiate Board, which runs more than 25 educational institutes and has about 50,000 students. Mr. Harish is a much sought after speaker in India and abroad and has given several professional speeches at prestigious events such as the India Calling Summit in Brussels, Belgium 2009, organized by the Indian Merchant Chambers and the International Fiscal Association of India. He has spoken in Dubai, Doha, Muscat and Jakarta on several occasions on topics such as FEMA, taxation collaborations and the legal requirements to operate a business in India, and at many seminars in India. Let's put our hands together and welcome Mr. Anil Harish.
Good afternoon, friends. There have been many changes in the laws relating to property in the last few months. There have been changes in the stamp duty applicable to legal licenses, for example. There has in fact even been a change in the name of the stamp duty law. It used to be the Bombay Stamp Act 1958. Now it's called the Maharashtra Stamp Act. The reason is that about a year and a half ago, the Maharashtra government passed a new law in which they said that all the old laws which still contain the name Bombay are now to be changed and these have to be called Maharashtra. Because as you know, there was originally the state of Bombay and then it was broken up into Maharashtra and Gujarat on 1st May 1960. So therefore, there was need to change. However, they did not want to call these the Maharashtra Stamp Act 1958 because there was no Maharashtra in those days. So they call it the Maharashtra Stamp Act without the reference to the year. Other laws which have had changes in names like this are, for instance, the Bombay Public Trust Act, which should now be the Maharashtra Public Trust Act. Then there's the Bombay Tenancy and Agricultural Lands Act. So you will come across these changes. There is also a change in the registration procedures. That up to now, till a few months ago, one could have a document, a power of attorney notarized, and you could still use that before the registrar. Today you cannot do so. You have to have your power of attorney registered if you want to use it for immovable property. And if the power of attorney is executed outside India, then it has, of course, to be signed before the consulate or high commission or embassy there. Then it has to come to India, then it has to go to the stamp office for adjudication, and then it can be used. But apart from these various changes that have taken place, two very significant ones are there which will affect all of us. One of these is in relation to the property taxes, and the other that we will talk about today is the TDS. Now, for all these years we've been agitated about property taxes because whenever any premises were given out on legal license basis, you would find that the taxes went up enormously. The Maharashtra, the BMC or MMC used to charge property tax on the basis of the rent that was being earned. And their percentage was 112.5% of the rent. So if you actually gave out premises for 1 lakh, you might have to pay 1,12,500 rupees by way of property tax. This of course was totally irrational. So then they would give a 10% discount and then they would give discounts depending upon your relationship with them. That was obviously not a transparent system. It was not a good system. It deterred many people from giving out their premises, especially when they had to face not only the property tax, but also the service tax and dealing with societies and non-occupancy charges, etc., etc. Now, that system is sought to be changed. But this change has taken a long time in coming. I remember participating in a panel discussion in the year 2003 on this proposed change from what was called the rateable value system to the capital value system. And now finally that has come in, it has gone through many different forms and discussions, etc. And on the face of it, then it appears to be reasonable. But, or at least it will be more objective and more easily determined. But the difficulty will be as we go forward in the years to come. Now, the Mumbai Municipal Corporation Act, this is an exception. It's not even, it's the Mumbai Act. It's not the Maharashtra Act. It's the Mumbai Municipal Corporation Act 1888. This has Chapter 8, which consists of sections 140 and 146 to 168, which relate to property taxes. As you can see, the word is property taxes, not tax. It's not one single tax, but property tax consists of 10 different taxes for different purposes, which are aggregated and then are called property taxes. Till recently, the basis of charging was a rateable value. What did this mean? In England, they charge rates and taxes. These are based on a certain value. So the rateable value was the value with reference to which the rates and taxes were charged. And this actually meant the rent or the notional rent of the property. So the basis of charging was the rateable value or the value for which the property might be expected to let from year to year, that is the notional rent. So if, for example, you were to let out one flat for 1 lakh of rupees a month and another identical flat for 1,000 rupees a month, the corporation could come back and tell you that we are not going to charge you only on 1,000 in the case of the second flat, we will charge you with reference to what we consider to be a fair rent or a notional rent. And the income tax also does that. There are a number of cases on that. There the issues are somewhat different. Anyway, now this is history, but just to tell you what it was before, and there are still some old cases which are pending in relation to those years. One famous one was of Dalawad Towers Cooperative Society, which went all the way to the Supreme Court, then came back to the High Court, and again is still in litigation. In the year 2003, the BMC passed a resolution. This said that up to 5 years from the date of implementation of capital value-based property tax, such tax for residential property will not be more than double of the property tax chargeable, and in the case of commercial property will be up to 3 times. So they said that no matter to what level we are going to take it up, at least for 5 years, we will lessen the impact on you, we'll just double it from the past. Then later on, we'll go up to the higher level. In 2010, draft rules were prepared, and objections were invited by 16/11/2010. I don't suppose many objections were given. In any case, those have been considered and the whole matter has been gone ahead. So the revised property tax system was approved on 26 June 2012, but with effect from 1st April 2010. I do not feel that it is retrospective, although many people feel that it is so, because of the fact that in the year 2003 itself they had passed that resolution saying that they were to implement it. So I don't feel that that will be a good ground of challenge. In any case, they said that this will be effective from 1st April 2010. And this new regime alters the basis of imposition and calculation of property tax by basing it on the capital value of the property building and not on the rent that one might expect to get from year to year. Now, rules had to be framed of how to determine the capital value. They could have easily done it on the basis of the stamp duty ready reckoner, because you know that the values for properties are mentioned and then there are the guidelines for valuation. Those are given in the first few pages of the reckoner book, which say that in the event the property is tenanted, it will be taken at 112 times the rent, a basement will be charged in such and such way, depending on the age of the building you get depreciation and so on. They could have adopted those, but they did not adopt those. they have adopted the basic capital value that is mentioned in the reckoner, but then all the other adjustments are done in accordance with these rules. So these rules are factors and categories of users of buildings or lands, assignment of weightages and multiplication fixation of capital value rules 2010. So the essential things are the categories of users and the weightages and multiplication that have to be done. So now there are two components in this. What is the value that is arrived at after all these factors, and then what is the rate of tax on that? Suppose you find that a particular property is worth ₹1 crore according to the capital value. The second thing is, what is the percentage of tax that you will have to pay on that basis? Per year, will you have to pay 0.5% or 1% or 2% or 5%? What will you have to pay? Now, there are different rates given for different categories. They have table 1, 2, 3, 4, 5, and I have broadly classified these, but you will have to go into detail in case of certain specific ones because there is an overlap amongst these. For instance, table 1 refers to residential buildings, etc. Table 2 is leases, industrial buildings, and other non-residential buildings. Table 3 is amusement parks, commercial and industrial land, non-residential buildings, airport land. So you can see that some kinds of non-residential buildings will fall in table 2 and others will fall in table 3. So when you are looking at any particular property and you want to determine the capital value, do go into the details of this. These are abbreviations which I have made for the purposes of this talk. Table 4 is hotels, and table 5 is very important. That's for banks and finance companies, etc. Now there are 10 taxes which are included in the scope of property taxes. These are the general tax, the water tax and the water benefit tax, the sewage tax and the sewage benefit tax, the municipal education cess, the state education cess, the employment guarantee cess, the tree cess and the street cess. These have already been there also even under the rateable value system, and they continue to be there under the capital value system. So these are 10, and then the total has to be given. Now, in the case of a residential building, they say, or a residential flat, the general tax will be 0.110% per annum of the capital value as determined in accordance with these rules. So 0.1%. Water tax will be 0.2%. Water benefit tax 0.069, sewage tax 0.163, etc. The total, as you can see, comes to 0.775% per annum, which means that after the period of that cap is over, ultimately when the municipal corporation wants to charge, they will charge 0.775% of the value of the property every year. Now, that is so in the case of residential buildings. In the case of industrial buildings, the rate comes to 1.407% per annum of the capital value. In the case of airport land and amusement parks, etc., it will be 1.759. In the case of hotels, it will be 2.8% per annum. And just see the last one, banks and finance companies, it is going to be 5.628% per annum as a property tax. Now, Mumbai has been the financial center of India, it's been the financial hub. But this one tax is probably going to finish the status of Mumbai. Today, you know that when commercial premises are given out on rent, let's say to banks, etc., then you have to factor in the property tax. But now, as time goes on, you'll have to be even more careful. The rents that you get nowadays for commercial premises that an owner would get would be around about 6% per annum. If out of that he has to pay 5.6%, what is he going to be left with? Only 0.3 or 0.4, out of which he'll have to pay society taxes, he'll have to maintain his property, and if there's something left over, he pays income tax. So, if it's going to be as much as this, then it's ultimately going to fall upon the lessees. But even now, when you're doing any given license or a lease for any of your clients with reference, and you're giving it out to a bank, or if you're doing it on behalf of a bank with an owner of property, you have to be mindful of this because this is going to come into effect in about 3 years from now. Usually leases, especially with banks and finance companies, are not just for 3 years, they're often for 5 years or even 9 years and 10 years, because banks don't want to keep shifting from place to place. So when the property taxes are so high, they have to be made aware of this, because if an owner says, well, I take 6% per annum, he'll find that he's getting nothing at all. And if the licensee or lessee says, yes, I'll pay you 6% per annum and I agree to pay the increases in property taxes, then they may end up paying 6% plus another 5%, which can just make the whole economics completely workable. So I think that this is, that I've always felt that the population density of Mumbai is very high. This is one factor that's going to reduce the population density. Some of the important rules are these. Rule 3 talks about the capital value of open land, vacant land other than land appurtenant to a building, and here the capital value is to be fixed in accordance with Rule 21. Rule 4 talks of the user categories of open land and the weightages by multiplication to be assigned there to get to capital value for buildings. 7 is weightage on account of age, and Rule 8 is the floor factor. The rules are so precise that in the case of a hoarding, for example, they say that the area of the hoarding is to be taken into account, and this is the land between the poles and the area of the hoarding. So if a hoarding is resting on 4 supports, then you have to take into account the land area which it is occupying and the area of the hoarding which is actually visible. So they have been so precise. No wonder they've taken 10 years to come out with these rules. Rule 10.1 talks about the built-up area of the flat, and this includes a terrace in exclusive possession, a mezzanine floor, a loft or attic, a dry balcony and niches. You know that a dry balcony and a niche was not counted for the purpose of FSI until, and thereafter they changed the rules and we have come to the fungible rule, fungible FSI concept in Mumbai. But for the purposes of these, for the property taxes, the dry balcony and niches will also be taken into account. From the Stamp Act point of view, it's not clear because the builder would have given you a carpet area certificate on the basis of FSI utilized. The society also may not take these into account, but now the municipal corporation will take these into account for determining the capital value of a property. And in the case of a building, the total area of the flats, the basements, the stilt, and even the refuge areas to be taken into account. When you buy a flat in a multi-story building, then you're concerned with the area of your own flat. You're not concerned with the area of the refuge floor. You know that in tall buildings, there has to be a refuge floor every 12 floors or so that in the event there's a fire or some catastrophe, then people can come down and they can be there for some time. And there should not be furniture and woodwork, etc. placed over them so that the fire does not actually does not easily move to another floor. But when calculating the built-up area of a building, for example, a self-owned building, or perhaps even in the case of municipal building belonging to a cooperative society, the BMC may charge a separate value for each flat and will also work out the value of the refuge floor and will probably charge the cooperative society the tax in respect of that refuge floor. Rule 10.4 says, if the total built-up area is not available, then carpet into 1.2 will result in the built-up area, which is the same as under the Stamp Act, as you are aware. What if there are tenants? If there are old tenants that you have in a property, you know there are many people on the Bakri system or who've been occupying for many, many years. In this case, what will happen? Here they said, we'll give you a concession, but that concession is only going to be that the capital value will be taken at 75% instead of the normal working. So you get a small discount, but it's not going to be a substantial discount. Let's see how this would work out. For instance, let's say a 1,000 square foot flat in South Mumbai would, according to the reckoner, be about 30,000 rupees a square foot, or 25,000 rupees if it's an old building. So if it's 25,000 into 1,000 square feet, it will come to 2.5 crores. Once the cap period is over, and I'll come to that again presently, the property tax in respect of that flat would be 0.77% of 2.5 crores. So about 1,75,000 or so per annum. So almost 15,000 rupees per month for a 1,000 square foot flat. And in the case of a tenancy building, even an old public building where the tenant is paying say 100 or 200 rupees or 300 rupees a month, it will still come to a substantial amount. It will come to about 1,20,000 or 1,30,000 rupees per annum. So about 10 or 11,000 rupees per square foot, even though the rent is just 300-400 rupees. Now the question will be, on whom will this fall? Will the burden fall on the landlord or will it fall on the tenant? Under the Rent Control Act, the landlord can pass on the burden to the tenant because these are permitted increases. That because the landlord is not making a profit out of this. He will collect it from the tenant and pay it over to the corporation. So the burden will fall upon the tenant ultimately, but before it actually falls upon the tenant and before the tenant starts paying, I'm sure there's going to be so much litigation, because if a tenant is called upon to go from 300 or 500 rupees a month to 10,500 rupees a month, obviously he's going to protest about that. And there will be petitions filed. It appears that some petitions have already been filed, and there will be, of course, many more. Now, there is an exception here, that it says that this concession of 25% will not be available in the event the premises have been given out to a licensee. So if there's an old tenancy, then you'll get that concession of 25%. But in the case of a live-in license, you will not get the concession. It will be the same basis as the capital value that we discussed earlier. Or if the premises are occupied by an employee of the landlord, then it will not entitle you to the concession. You will still have to pay at the regular rate as specified in that earlier table. Rule 13 talks about religious buildings and the base value and the weightages. Rule 14 relates to the terrace. If it's a non-residential building, then the value of the terrace will be 40% of the regular capital value system. And in the case of a residential terrace, it will be 10%. A mezzanine will be taken at 70%, an attic at 50%, and dry balconies and niches and refuge area will be taken at 25% of the normal value. If there's land with FSI of more than one, then the value is to be increased proportionally. Now we come to the actual calculation of the value. So the capital value is the final figure that you get. This is with reference to the base value which you will find from the stamp duty levy reckoner, multiplied by the weightage of multiplication as per the user category which you saw earlier, namely these 40%, 70%, 25%, etc. And the permissible or approved FSI and the area of the land, because this is in the case of open land. So the capital value will be the product of the base value and the user category and the FSI and the area of the land, the size of the plot. In the case of a building, it will be the base value multiplied by the user category and then multiplied by the nature and type of building. Is it a pakka structure? Is it a kacha structure? They've got different weightages for that, just as they have in the Stamp Act. Then there's the age factor. How old is the building? And on what floor are you located? Now this actually should not be relevant at all for the municipal corporation. Suppose there are two buildings next to each other. One of them is 50 years old and the other is 20 years old. Both of them occupy the same amount of space. They've got that much frontage on the road. Everything is identical except the age of the building. The property taxes should not be dependent upon the age of the building. The value may change because a buyer may want to buy a newer building rather than an old building. Therefore, for stamp duty, I can understand that distinction between an old and a new. But I feel that this basis of charging property tax with reference to the age of a building is not actually correct. Why should a newer building have to be more than an older building? In fact, the older building might need more facilities from the municipal corporation. The water pipes may get corroded. There may be more chance of fire over there. Fire engines may have to come there more frequently than in the case of old buildings. We know that in the monsoons, older buildings tend to be more weak. But this is one of the factors that has been taken into account. And the other factor that is relevant is the floor factor. If you are on this floor of a building, then you have to pay, there's a certain weightage attached to that. If you are on a higher floor, there's a higher weightage. And therefore, you will find two people in the same building paying a different amount by way of property tax. So you can see how much calculation has to be done for all the different units in Bombay, and the BMC has sent out these bills to societies. Societies have passed it on to their members. Members have to go into each of these calculations, then give it to the BMC, and the BMC knew that there were going to be a lot of appeals, which is why they provided you with a complaint form. If you have an objection, they say you can send it in this form. Now they say very clearly that the guidelines of stamp duty valuation will not apply for property tax. While the base value will be taken from the stamp duty reckoner, the other guidelines will not apply. The details of factors and user categories and the weightages are specified in the schedule. So there's open land, residential buildings, shops, industrial buildings, etc. And in terms of nature and type of building, age and floor factor, again, there are these different rules. So let's see this. Residential land will be classified, will get a weightage of 1. Land to be used for residential purposes. Land to be used for commercial purposes will get a weightage of 1.25. Actually, in Mumbai, we know it's really the other way around. In fact, residential property is double or 3 times as much as commercial property in some places. But here they valued even industrial land as being more valuable than residential land. It's 1.1 as compared to 1. Now, if land is under reservation, if there's a partial reservation, then it's to be valued at 0.1, and if it's total reservation, it's 0.01. In the case of residential buildings, a flat will have a normal weightage of 1, a bungalow will have 1.25, a car park in the stilt or basement will have 0.25, and even though a swimming pool does not use FSI, it will be counted as 1, so as much as the value of the flat. Offices will be 1, shops, educational institutions get some concession, and hotels will be 1.1 or 1.25. And for community halls, even a society office is going to be valued as property tax will have to be paid with reference to that. A luxurious building will be valued at 1.2, a pakka building at 0.7, and a kacha building at 0.5. Now, the weightage is also to be given. So if a building is 0 to 5 years old, then the weightage will be the full 1. If it is 5 to 10 years old, then there's only a 3% depreciation. You know, under the Stamp Act, they have different reservations. They have depreciation, they have 10, 20, 30, 40%. Here it's 3% between 5 and 10 years, and these are the remaining figures. A basement will be taken at 0.7. If it's used for car parking, a basement other than car parking will be taken as much as 1. So it will be taken at the same value as upper floors, like the first floor, etc. Ground floor to fourth floor 1, then 1.05, 1.1, 1.15, and so on. And they've even provided for more than 100 floors. So they're really looking into the future. The value of a 100th floor flat will be, or the 101st floor flat will be 1.35 times the value of a first floor flat. So you can, this is an example that is given in the rules themselves. Now here I find a little bit of contradiction or lack of clarity in the final figure. So let's see how this would work out. If the base value per square meter is 80,600 rupees and the built-up area is 80 square meters, the user category is residential, so the weightage is 1. If it's an RCC building but not a luxurious building, then it's also 1. If it's on the 12th floor, the weightage is 1.1. And if it's 6 years old, then the depreciation is only 3%. So it will be multiplied by 0.97. And here they say that the rate of tax will be 0.348% per annum. But you saw in the table 1 that I pointed out to you, it's 0.775%. So I do not know why they've given this, but I found this difference even in 2 different bills that the municipal corporation has sent to different people. So anyway, on this basis, the capital value will work out on the basis of this formula for an 80 square meter flat to 68 lakhs of rupees, and at the 0.348%, the property tax will come out to be almost 2,000 rupees per month. Now, the municipal corporation is going to collect so much more revenue. They say that they've been collecting about 3,200 crores of rupees per year. Let's see how much impact this increase will have on them in the current year and then as we go forward. So in 2010-11, suppose the amount that they were collecting from residential premises was R, whatever figure that may be. Suppose it was 1500 crores and commercial was 1700 or whatever. So R was the total figure for residential and C for commercial. And it would have been more or less the same for 11-12. Now in 12-13, when they sent out the bills, they sent out the bill for R plus an additional R for 2010-11 because they were collecting double the tax from 2010-11 onwards. Therefore, the bill that came to you in 2012-13 would be for the third line, that is for that R, plus an addition for 2010-11, plus an addition for 2011-12 and for 2012-13. That means your bill in 2012-13 was actually 4R. And in the case of commercial, your bill was C plus 2C plus 2C plus 2C, that means 7C. So you can see that the municipal corporation is going to get so much more in this year. Of course, they have not sent out all the bills, but they have sent out a substantial number, and they may not have got all the revenue before March because they've given time till 30th June. I may tell you that what some societies are doing is that since the time to pay has been extended up to 30th June 2013, some societies are waiting till about the 5th or 10th of June till the courts reopen, because some people have filed writ petitions. Now, in the event that the High Court grants a stay against collection of these amounts, then the societies may not pay this additional R or 2C, etc., but may just pay the old amounts. But if the High Court doesn't grant a stay, then everyone will have to pay by 30th June. But in 2013-14, the amount that will be collected will be 2R and 3C. In 2014-15, which will be the fifth of the years, again it will be 2R and 3C because it was capped according to that resolution. In 2015-16, they have said we will increase by 40% over the preceding year. That means 2R will become 2.8R and 3C will become 4.2C. So you can see that the property taxes are going to go up a great deal. And what happens in 2016-17? It will go up to those percentages, 0.775, going up to 5.628, etc. So the real problem is going to hit us in 2016-17. Because then there will be no limit, no cap, and we will see what the capital value at that time is going to be. Take, for example, premises of say 3,000 square feet at Nariman Point, if they've been given to a bank or a financial institution. Now the reckoner rate in Nariman Point is around about 30,000 rupees or 25,000 rupees a square foot. In 3 years from now, in 16-17, the value will be somewhat more. Suppose the 3,000 square feet premises come to a figure of say 10 crores of rupees. Then the property tax on that 10 crores will be 56 lakhs of rupees. So for a 3,000 square foot office, which every bank would have, they'll have more than that probably, they'll have to pay almost 5 lakhs of rupees every month by way of property tax. And this is the impact that's going to have. The municipal corporation will have so much money, they don't need an LDT at all, but they want to collect that as well. Now, this is the kind of bill, a covering letter that was sent out by the municipal corporation. Is it legible there? But I'll just read out some portions. In exercise of the powers conferred by section 154(1)(a) and 154(1)(b) of the MMC Act, I hereby fix the capital value of the below mentioned premises at say 52 crores 13 lakhs. With the date of effect as shown in the attached Annexure A. Complaints, if any, shall be made in the attached format by lodging and delivery at the office of the Assistant Collector within 21 days. So they expected many complaints, and they did get about 42,000 complaints. And this is the format of the covering letter for the complaint. To the Assistant Assessor, I have received the special notice fixing the capital value at 52 crores. I hereby lodge the complaint against the capital value fixed for the reasons mentioned as per detailed below, etc. And you can give those reasons. But the Property Owners Association and other associations have said this is not a proper format. We have to challenge the entire levy on the basis of the law and on the basis of the facts, and so they prepared a different format for making a complaint. Now this is the kind of bill that has come from 1/4/2012 to 39/2012, 1/4, and then 1/10/2012 to 31/3/2013, and so on. The reverse of the bill specifies those percentages, table 1, 2, 3, 4, 5, which I had referred to in the earlier slide, which is for the general tax, the water benefit tax, etc., which came to 0.775, going up to 5.628. So these are stated on the reverse of the bill. Now, these are different bills. Now, this is one example of a bill that we got. You can see the red arrows. The capital value in the first case came to 23,18,170. And they said the tax on the capital value would be 8,090 rupees. And here they've taken it at 0.34%. You can see that's written in red on the top. So even though their own figures show 0.775, in this particular case they are taking 0.34, which is in accordance with the rules. So the bills are not in accordance with the rules. What ultimately will prevail, we do not know. But in this case, they took a figure of 0.34%, so it came to 8,090 rupees. But they said that the existing tax is 450 rupees. Therefore, since these are residential premises, this will be doubled to 900 rupees. You will have to pay not 8,090, you will have to pay 900 rupees in this year for these particular premises. Now, another bill that we got did in fact show 0.765 and not 0.775 as they said, but 0.765. In this case, the capital value came to 66,72,230. The tax on the capital value at 0.765 would come to 51,000 rupees. Existing tax was 4,000, which would become 8,500. So you can see they have themselves given different figures, but I don't think anyone will complain against these because the 0.7% will not have any grounds for complaint, but the 0.348% will not complain because he's getting a benefit anyway. Insofar as slums are concerned, and the population of slums is more than 50% of the entire population of Poppy. But insofar as slums are concerned, they have not made any provision for taxation, not even with reference to the land value. The rules make no mention of taxing, even at a subsidized rate, the dwellers of slum areas, although these settlements make up almost 60%. Under the Jawaharlal Nehru Urban Renewal Mission, the BMC must bring in 85% of the properties in the city within the tax net, whereas a substantial part of Mumbai structures have been characterized as slum dwellings. When they will